Hello, and welcome to my parlor. I am George Washington.
And I am Thomas Jefferson. Insofar as I was minister to France at the time of the Constitution's writing, and because he could not be here, I am standing in for James Madison, a great patriot and friend.
Those of you who are familiar with me will recall that I delegated my powers and remained aloof of the political controversy that marked my administration. Among those serving under my direction was Mr. Jefferson, who performed admirably as Secretary of State.
I am flattered, sir.
We come before you on this occasion to impart what our friend, Mr. Paine, might term common sense.
Indeed, he wrote a pamphlet by that very title.
What we hope to impart upon you in this proceeding is the nature of our intent in forming our Union.
Toward this end, we shall first provide historical perspective for our motives. Primary among our objectives was facilitating a uniform commerce between the states, and for the general defense, for our newly acquired liberty seemed threatened by many quarters. Moreover, we feared the intercession of foreign powers seeking advantage in the petty squabbles between the states.
And also to bring order to the chaos which had followed the end of hostilities with Britain. A general anarchy which seemed to grip the states in turmoil that threatened to spill over from state to state.
Our intent was to form a federated nation, composed of the many states.
Let us here clarify our language. The word state refers to a condition of autonomy termed sovereignty, implying total independence. This was of course of no advantage above the existing confederation, as my dear friend Alexander Hamilton pointed out in convention, that leaving the states in possession of their sovereignty could not possibly answer the purpose of the convention, since they constantly pursue internal interests adverse to those of the whole.
Indeed, we viewed ourselves as citizens of our state, not of the United States. When Mr. Washington and I spoke of country, we spoke of Virginia.
Indeed. Among our concerns was that the central government be endowed with too great a power, and use such power to suppress our liberties.
Perhaps the first great instance of such a concern came during the administration of John Adams, when, to suppress dissent with his policies, he and his Federalists, what you would term conservatives, imposed the Alien and Sedition Acts, and imprisoned those who spoke out against his policies.
I had found partisan bickering as distasteful as the internecine bickering between the states prior to forming our nation, and not participated in the debate between opposing views, which began during my terms in office.
James Madison and I originally formed the Democratic-Republican Party to pose a united opposition to Alexander Hamilton's fiscal policies, and the party became further energized when we opposed Mr. Adams's policies, and invoked a demon which threatens our unity yet today. Together, Mr. Madison and I wrote what are collectively called the Kentucky and Virginia resolutions, which invoked the principle of states' rights, arguing therein that the states had the right to nullify an act of the federal government which the state found offensive to its citizens' general interest.
But we digress, Mr. Jefferson.
Verily. Shall we then approach this subject at another meeting?
Agreed. This does, however, segue to the topic at hand. What had the Founding Fathers intended when writing the Constitution? As president of the proceedings, I can say that the debate was lively, but reached compromise satisfactory to all but a few delegates.
Yet, soon thereafter, it was amended with what are called the Bill of Rights.
And amended again and again, over the course of time, to include 27 total amendments as of today's date.
Surely then, the original intent is not entirely within the purview of the Founding Fathers.
The first use of the concept of original intent was in 1793, when then Supreme Court Chief Justice John Jay wrote the majority decision in Chisholm v. Georgia.
Justice Jay had of course been a Federalist, and carried the bias evidenced by his authorship of portions of what are currently known as the Federalist Papers.
The case of Chisholm v. Georgia had been a states' rights issue, and the court had ruled in favor of the federal government, citing the original intent of the Constitution's framers.
Thereafter, Original intent is generally argued as having principles opposite to those established in the case, and those who call themselves conservatives argue their point most fervently.
The argument is, however, specious rhetoric, regardless of the viewpoint being argued. In the absence of unanimous agreement, and in view of the sentiment expressed in that most eloquent statement of principle upon which we presumed the right to separate from Mother England, the Declaration of Independence, any argument based on original intent is absurd, and evidence of the most devious intent, if not ignorance so profound as to be pitiable.
Thank you for that high praise, Mr. Washington. You are most gracious. Within the Declaration, I wrote that governments are instituted among men, deriving their just powers from the consent of the governed. That whenever any form of government becomes destructive of these ends, it is the right of the people to alter or to abolish it, and to institute new government, laying its foundation on such principles and organizing its powers in such form as to them shall seem most likely to effect their safety and happiness.
Other evidence discrediting the argument of original intent abounds, but in the interest of brevity, let us examine only the argument of Thomas Paine in his pamphlet, The Rights of Man.
Mr. Paine was largely the voice of reason and explicator of the justification in our great experiment. His pamphlet, Common Sense, had most convincingly stated the principles upon which we had acted. A passage from another of his works, The Rights of Man, very succinctly addresses the matter of original intent and an underlying sentiment in our revolution. Therein he said, "A greater absurdity cannot present itself to the understanding of man than what Mr. Burke offers to his readers. He tells them, and he tells the world to come, that a certain body of men who existed 100 years ago made a law, and that there does not exist in the nation, nor ever will, nor ever can, a power to alter it."
I mentioned earlier that the very instrument purported to document our original intent has been amended through 27 additional articles, and further that no unanimity existed among the several men from each state who met in convention in Philadelphia in 1787. Let us therefore examine the instrument itself. I quote here from Article 5. "The Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution, or, on the application of the legislatures of 2/3 of the several states, shall call a convention for proposing amendments, which, in either case, shall be valid to all intents and purposes, as part of this Constitution, when ratified by the legislatures of 3/4 of the several states, or by conventions in 3/4 thereof."
Indeed, the only evidence of an original intent was in Mr. Jay's spurious argument to justify a decision to which he was favorably disposed. Since then, other justices who wished to justify decisions to which they were favorably disposed, or denounce those which they found vexing, have perpetuated a myth of a group of founding fathers with a singular vision, while in fact they agreed on one thing only, that there should be a nation founded on republican principles which forever guarded jealously the rights of its citizens.
How this was to be accomplished was never agreed upon, and is the very substance of disagreement among men yet today.
Hear. It is in some men's nature to doubt all but that which they wish to hear, and no doubt many who hear this will doubt what we have said. Though they have no evidence to the contrary, they will reject all evidence in addition to what we have presented at this instance. To you, I suggest arguing your position on its merit, that is to say, substantive argument, instead of rhetorical reliance on men these centuries since passed away, and half or more of whom would not support your argument.